Imagine spending thousands of dollars to lower your electric bill. You do your homework, you hire a professional installer, you follow state laws. You even talk with your HOA. Then, one day, a lawsuit arrives. Not from the utility company, not from the city, not from the state, but from your own homeowners association. And according to that lawsuit, some of your solar panels have to go. That's exactly what happened to Mark and Jennifer Bassler, a firefighter and a second-grade teacher from Belleville, Illinois. What started as a home improvement project became a 2-year legal battle, cost the family approximately $53,000 in legal fees, and helped spotlight a growing fight over who really controls what homeowners can do with their own property. Here's what happened. In 2020, the Basslers worked with a solar company to design a system capable of generating nearly all of their home's electricity needs. The design called for solar panels on both the front and rear sections of the roof. The Orchard Homes Association objected. According to the HOA, its architectural guidelines only permitted solar panels on rear-facing roof surfaces whenever possible. The Basslers believed those restrictions would make the system significantly less effective. Rather than abandon the project, they moved forward with installation. The panels were installed in December of 2020. Shortly afterwards, the HOA filed lawsuits seeking a court-order requiring the front-facing panels be removed or relocated. What had been a simple home improvement project suddenly became a legal battle. This wasn't just a disagreement about appearance. The Basslers argued that moving the panels where the HOA wanted them would dramatically reduce the system's performance. According to testimony from solar installer, relocating the disputed panels would reduce the system's output by approximately 35%. Think about that. The family wasn't fighting to keep a certain look. They were fighting to preserve roughly 1/3 of the energy production they had paid for. That fact became central to the dispute. Illinois law already protected homeowners' ability to install solar energy systems. The question was whether an HOA could impose restrictions that substantially reduced a system's effectiveness. The Basslers believed the answer was no. The HOA believed its architectural standards gave it authority. The courts would eventually become involved. As the lawsuit moved forward, the dispute attracted attention well beyond the neighborhood. Solar advocates, energy companies, attorneys, and state lawmakers. Many viewed the Basslers' case as an example of a larger problem. Illinois law supported residential solar power, but some believed that the protections were not clear enough when homeowners associations became involved. While the lawsuit was still active, lawmakers were already considering legislation that would strengthen solar rights for homeowners throughout Illinois. The Basslers suddenly found themselves at the center of a debate much larger than their own roof. In 2021, Illinois Governor J.B. Pritzker signed House Bill 644. The new legislation strengthened protections for homeowners installing solar energy systems. Among its provisions, homeowners associations could no longer impose restrictions that reduced solar systems' performance by more than 10%. Remember the Basslers? Their installer estimated the HOA's preferred design would reduce production by approximately 35%, more than 3 times the new limit. Jennifer Bassler later said the legislation gave her family renewed confidence that they were on the right side of the law. The legal battle continued, but the landscape had changed. The state had spoken. In September of 2022, after nearly 2 years of litigation, the Orchards HOA voluntarily dismissed its lawsuit. The case ended without a final court ruling. No judge declared either side the winner, but the practical result was clear. The Basslers kept their solar panels. The HOA's effort to force their removal was over. Unfortunately, the legal victory came at a significant cost. The Basslers later reported spending approximately $53,000 defending their solar installation. Because the lawsuit ended through dismissal rather than a final judgment, they were unable to recover those legal expenses. Mark Bassler later suggested that changes in Illinois law made the HOA's position increasingly difficult to defend. Whether or not that was the reason, the timing raised questions. After nearly 2 years of litigation, the lawsuit simply disappeared. The solar panels remained exactly where they were. The most remarkable part of this story isn't that an HOA challenged a solar installation. It's what happened next. A firefighter and a teacher installed solar panels to lower their electric bills. Their HOA sued. State lawmakers strengthened homeowner protections. The lawsuit was dismissed, and the panels stayed. But the family still spent approximately $53,000 defending a project that remained on their roof the entire time. The Basslers never set out to become advocates. They just wanted solar panels. Instead, they became part of a larger conversation about property rights, renewable energy, and how much power a homeowners association should have over its home it governs. And that's what makes this one of the most expensive HOA disputes you've probably ever heard of.